Friends, yesterday I discussed that detenue, after service of the detention order and ground of detention, the list of relied upon document and the documents have remedy to represent against the detention order to the authorities, that is, detention authority itself, state government and central government. The detenue can also represent to the advisory board, which has to hear him and give its opinion within 11 weeks of the detention. Yesterday I discussed that representation has to be sent to the respective authorities for their consideration. This representation has to be considered independent of the view of the advisory board. This representation has to be considered within a reasonable time, as the personal liberty of the detainee is involved, who is detained without having any recourse to bail, as is in other cases. The detainee, when represent to various authorities, has to represent his case in such a way that all the grounds taken by detaining authority while formulating the ground of detention and arriving at subjective satisfaction has to be looked into. So once detention order is passed and the ground of detention is served, the first and foremost duty is to go through the ground of detention on the basis of which the detention order has been passed. In the ground, initial paras are of the investigation conducted by sponsoring authorities, including arrest, remand, and bail if granted. Then detaining authority arrives at its subjective satisfaction, stating therein that looking into the fact of the above investigation, the person against whom the order is passed has propensity to indulge into judicial activities in future, and therefore it is imperative to that person to be detained under the respective Detention Act. The detaining authority has to mention clearly in the ground of detention as to how much time it has taken from the date of receiving of the proposal and passing of the order. It has to also mention as to how many pages of the documents it has scrutinized while arriving at the subject satisfaction and formulating the ground of detention. The detaining authority in the ground of detention itself has to mention that the detainee has got right to represent against the detention order to various authorities and advisory board. If these authorities or advisory board are not mentioned in the ground of detention, then the order will be vacated. Now, as far as the representation is concerned, representation has to include the basic facts of the case leading to passing of the detention order, and then it has to also include the grounds on which the detention order and the ground of detention are being challenged. First and foremost thing is that by looking at the document furnished to the detainee at the time of execution of order, all the documents has to be carefully scrutinized so as to arrive at whether there is any delay in passing the detention order. If a detention order is passed after a long and unexplained delay, then the live link of the detainee with that prejudicial activity is snapped and detention order is vacated on that ground. So the first ground has to be taken whether there is delay in passing the detention order. The second ground which may be taken would be if the detention order has been passed in a hurry, in the sense that if a detention order is passed after 5 days or 6 days from the date of receipt of the proposal, and the documents which were part and parcel of the proposal are voluminous, then it is humanly impossible for the detaining authority to scrutinize all the documents and pass detention order and formulate the ground. Third part is whether there is non-application of mind by detaining authority. It is my experience during last 10 years of practice in detention matter that the detaining authority does not apply its own independent mind and arrive at subjudicial satisfaction. Detaining authority normally adopts bodily the ground mentioned in the detention itself. I have been successful in many cases where I have demonstrated before the court as to how it is verbatim reproduction of the proposal. Then, if any document relating to arrest, remand, or bail have not been considered, any detection which has been filed has not been considered, then also it results into non-application of mind and the detention order is vacated. Sometimes the detention order and the ground of detention is in a different language which is normally known to the detainee. If a person knows Hindi and the ground of detention is in English, then detainee authority ought to supply the translated copy of detention and ground of detention to the detainee. As the detainee has got right to know on what ground he has been detained. In numerous cases, it is seen that the detaining authority does not supply the translated copy of detention order, ground of detention, and the documents to the detainee, which result into passing of the detention order. It is also important that a person who does not know either Hindi or English but other language, then also the ground of detention, detention order, and the documents have to be translated into that language and served upon the detainee within reasonable time, else the detention will be vitiated. These are broadly certain feature of the representation which has to be taken into consideration while drafting the representation and then sending it to the various authorities. It is not necessary that the representation has to be sent separately to the authorities. A common representation addressed to all the authorities, including advisory board, is sufficient, because each authority has to consider representation independently of one another. It is observed that in certain cases, state government does not dispose of the representation within reasonable time, as the additional chief secretary or the chief secretary home is busy in other work. In one case, plea has been taken that due to assembly session, the additional chief secretary was away from Mumbai and therefore the representation could not be disposed of within reasonable time. The court has observed that the fundamental right of a human being is infringed, which is paramount in our democracy, and Article 22(5) guarantees that his representation has to be considered expeditiously, and thus further detention of the detainee was vitiated. Friends, this is in nutshell the representation part of the detention cases. In the next video, I will deal with the writ of habeas corpus, which has to be filed before High Court or Supreme Court, as the case may be. It is not necessary that the detainee has to wait for the disposal of the representation or the result of the advisory board. As fundamental right is vitiated immediately after receipt of the detention order, habeas corpus writ petition has to be filed before the court. If possible, a production precipi or circulation precipi may be moved so that the matter may be admitted, rule may be issued, and respondent are giving time to file their say, that is affidavit in reply. I will deal all these aspects in the next video. In the meantime, it is again requested to please share this video so that the prospective detainees, the officers who are enforcing detention law, the students of law, and advocates are benefited. This sharing business will also provide me motivation to further upload video on detention matter, which will be beneficial to